Hey there, everybody. Just thought we would go ahead and record some of these court cases. That way we have them on record and we can start correlating them with other court case records. The first one that I want to start with is the Church of Scientology versus Jerry Armstrong, 1991. I will put a copy of this into the case files, into the folder, so that way you have a copy of it. This is an annotated case. This was the 2nd District, Division 3, July 29th, 1991. Church of Scientology of California et al., plaintiffs and appellants versus Gerald Armstrong, defender and respondent. This was a claim against Gerald Armstrong, for taking, here, I'm going to go ahead and just read it. It'd be a lot easier. Los Angeles County, so Los Angeles, California. Counsel, Bowden, Standard, Krinsky, and Lieberman. Bowles and Moxon, Kendrick Moxon, there you go, folks. Timothy Bowles, Kendrick Moxon, Michelle Lee Hertzberg for plaintiffs and appellants. Gerald Armstrong, improper, Toby Plevin, Paul Morantz, and Michael Walton for the defendant and respondent. Lawrence Larry Wollersheim, who was also part of Scientology, provided amicus curiae on behalf of the defendant and respondent. So on behalf of Gerald. Here's the opinion. In Consolidated Appeals, the Church of Scientology of California, the Church, and Mary Sue Hubbard, hereinafter collectively plaintiffs, appeal from an order after appealable judgment unsealing the file in the Church of Scientology of California v. Gerald Armstrong, and from the judgment entered into the case B025920, we vacate the order and affirm the judgment. So there was an appellate decision. This is the appellate opinion, the appellate decision, saying that the original lower court's judgment is affirmed and they vacate their order. In the underlying action, the church sued Armstrong, a former church worker, alleging he converted to his own use confidential archive materials and disseminated the same to unauthorized persons, thereby breaching his fiduciary duty to the church, which sought return of the documents, injunctive relief against further dissemination of the information contained therein, imposition of a constructive trust over the property, and any profits Armstrong might realize from his use of the materials, as well as damages. Mary Sue Hubbard, wife of the church founder L. Ron Hubbard, intervened into the action, alleging causes of action for conversion, invasion of privacy, possession of personal property. Basically, they're saying that he took L. Ron Hubbard's shit. That's the long and short of it, and kept it. And declaratory and injunctive relief. Armstrong countersued, cross-complained, seeking damages for fraud, intentional infliction of emotional distress, libel, breach of contract, and tortious interference with contract. With respect to the complaint and intervention, the trial court found that the church had made out a prima facie case of conversion. So they made out saying that he took their stuff, and breach of confidence, that they he broke the contract, and Mary Sue entered into that with them. So it was both of them. However, the court also determined that Armstrong's conduct was justified and that he believed the church threatened harm to him and his wife, and that he could prevent such harm by taking and keeping the documents. Following those determinations, the court made and entered an order entitled Judgment on October 10th, 1984, ordering and adjudging that plaintiffs take nothing by their complaint and intervention, and that the defendant, Armstrong, have and recover his costs and disbursements. Plaintiffs filed notice of appeal from that order. So, give and take back and forth is that they went through the appeal process. The appeal process ordered again. They vacated at the appellate level and said the original judgment stood, and both costs of the appeal for both sides, each of them had to pay their own, but they still held the judgment that the Church of Scientology owed him for his damages and for his cost for the original judgment. So one thing happened in this one, though, is that they sealed the documents. However, in 1988, Ben Corridan, who was a party to other litigation against the church, moved to unseal the record in the case. So that way, he could use them in his case. And what was sealed was all the evidence showing that, let me go back, let me tell you what it said. I don't want to misspeak. That there was evidence that Jerry Armstrong believed that the church threatened harm to him and his wife, so there was evidence to that, and that he could prevent it by taking the documents. So he felt that he and his wife would be threatened and would come harm to them. There would be harm to them. It does tell a little bit on what that was. They were followed, they were chased, they were threatened by PIs. So there was some record of that in this. However, all the rest of the records were closed. They fought back and forth on sealing of the records. So these are the items that in 1980, fearing a raid by law enforcement agencies, this is how he got his hands on all those documents. They went ahead and ordered everybody to shred documents. We were just talking about that yesterday, weren't we? About how Lara and everybody had shredders. Jamie and everybody had a shredder in every office because you just shred it. And that was because of this. Because they were afraid that any of those documents would still be around. In the course of all the inspection of the documents, Armstrong reviewed a box containing Hubbard's personal letters, diaries, and other writings. And so he preserved those. He then used those along with a writer, Omar Garrison, to write a biography. Well, they feared that Jerry Armstrong knew too much, and so they did a security check on him, an interrogation while connected to a crude light detector called an E-meter to determine what materials he delivered to Garrison and to meet charges that he was speaking out against Hubbard. So they went ahead and they declared Jerry Armstrong, for those who don't know, meaning that they declared him a suppressive person and that he was against L. Ron Hubbard and against the church. He was anti-Scientologist. So with that, knowing that he was being declared, Jerry Armstrong and his wife copied a number of the documents, which he delivered to Garrison for his work for the biography. And after he leaving, he went ahead and he gave copies to his lawyer because he knew that he knew what the fair game doctrine was. And to those declared subjected, Armstrong to the fair game doctrine, which permits a suppressive person to be tricked, sued, or lied to, or destroyed, deprived of property, or injured by any means by any Scientologist. At the same time, the church confiscated all the photographs of Hubbard and others that Armstrong had arranged to sell to one Virgil Wilhite. When Armstrong met with church members and demanded the return of the photographs, he was ordered from the church property and told to get an attorney. Thereafter, he received a letter from the church council threatening him with a lawsuit. He became aware of private investigators watching his house and following him. These events caused Armstrong to fear that his life and that of his wife were in danger, and that he would be made the target of costly and harassing lawsuits. Go figure. The author, Garrison, feared that his home would be burglarized by church personnel seeking to retrieve the documents in his possession. For these reasons, Armstrong took a number of the documents from Garrison and sent them to his attorney. Following commencement of the instant action, Armstrong was pushed or shoved by one of the church's investigators. In a later incident, his elbow was struck by an investigator's vehicle. Still later, the same investigator pulled in front of Armstrong on a freeway and slammed on his brakes. The investigator's vehicle also crossed a line as if to push Armstrong off the road. Plaintiff's position is that the investigators were hired solely for the purpose of regaining the documents taken by Armstrong. So this went back and forth, and the final judgment was that, yep, all that stuff happened, and Armstrong had reason to feel that his life was being threatened by all of these incidences, and that he had reason to take those documents. So that was the decision. Now, all of the exact details and all the records and all of the witnesses, all of the testimony is under seal unless you have a case that you can use it for. And they fought back and forth on whether or not these were public records, whether they need to be sealed, whether the order need to be reversed. And at this time, nothing ever really came of it. I read through the whole thing, and it basically gives argument for and against. And I think it finally came down to that the record would be sealed unless there would be need. So if anybody is in need of those records, you can order for them to be unsealed or to get a copy of those records. I'll just scroll through. So in this case, you had justification for taking of his own records, his own PC folders, and his own audit sessions, all of those records against L. Ron Hubbard and the upper management and executive branch. And justification was and found in evidence of fair gaming practices, abuse, hiring of a third party to make those abuses and make the fair gaming, policy that's in record of showing that SPs are under fair game tactics, and that is policy. So there's basically quite a bit of information that you can gather from this. So I hope that was helpful for you, and I will go ahead and post a copy to this document that I have found. And thank you very much. We'll see you on the next one.